abusia for yemo bibia kwaba na yemfa Mega TV and platform we eso yakopon hyiraw se de bia unya adaje na ojembre na wo hwe yem platform we abusia Egyapa Mercer second constituency Western region member of parliament Sansona Yura Godwin Edudzi Tamakloe National Petroleum Authority CEO Yura John Mahama and Oman sa appointment just recently mobile by mu na unim omo akoko clash ewo Metro TV Good Morning Ghana shows Moro Moro the show no eso na nina the removal of Chief Justice and mami Gertrude Araba Seki Torkonoo and the removal eho she say in say 5-member committee atnase ayera domlevo eka ho a omo hwehwe nsemu na omo ebobu ni nsem se maame no yenyinadi ana se ontena na yi ne office but she say no ka say the Yura John Dramani Mahama President of the Republic of Ghana was suspending no enti onye Chief Justice bill Yura bafu boni and acting Chief Justice abusia yenko ne enti nsem we emu enchiremu na ekoba yedi na kai na abesomwo yem platform kesi we so ye be so say obe subscribe na do comment atungo bra nkomodidi ni ekoso nyankopon enkoso wa enhira obibia hanom you are number 1 authentic platform Mega TV nyankopon enhira yenti nsem no ekoba ebeto aso.
And I feel like stepping in there myself.
He would be signing only the invoice.
Right. Yeah. Is that so?
Yeah.
And you don't have office staff who do that.
Okay, but that said, I think that you asked a very important question, and I want to start from that. Whether or not there is any basis at all. You see, one of the things that I don't want to do is to pretend that I am wiser than the Council of State members who the President, in compliance with the constitutional provision, consulted. I cannot sit here on this platform and suggest even remotely that I am wiser than the distinguished chair of the Council of State, the Honorable former Speaker Do Ajaho. I cannot also sit here and say I am wiser than the Honorable Betimod Idrisu, the Honorable Mohammed Mumuni, the distinguished jurist Vida Koto Banfo, a retired Supreme Court judge, Her Ladyship Justice Sophia Akufo, a retired Chief Justice, and all the eminent people that constitute the Council of State. I cannot sit here for a minute and pretend to be wiser than them. There's a reason why in the superior wisdom of the framers of the 1992 Constitution, they decided to put a Council of State. Right. And now you will notice that when it comes to Article 146, there are essentially two categories of individuals that are recognized. Justices of the superior courts stand alone, and what do you call a special procedure when it borders on the Chief Justice? Right. There must be a reason. And so you notice that in Article 146, when the petition relates to a justice of the superior court, that's a high court, Court of Appeal, Supreme Court, stand alone. Even the determination of the prima facie is reserved for the Chief Justice as an individual to do that. Right. But because of the unique role, the countervailing position of the Chief Justice in ensuring that there is proper checks and balance, the framers of the Constitution say that when it comes to the Chief Justice and her removal process, go to the Council of State. Wise men and let them properly advise. Let the president consult them. I am being called upon at this juncture to impugn the reasoning, the finding that those wise men and women have decided. Do I even have the capacity to do that? Obviously, it creates a challenge. And so I strongly believe that in the wisdom of the framers of the Constitution, they realized that the Chief Justice is just an important person, stand alone. Look, when it comes to commissioner, any of the commissioners of the Electoral Commission, Article 146, however, it is the Chief Justice stand alone that makes the prima facie determination.
Right.
The Auditor General and such heads of independent constitutional bodies, it is the Chief Justice stand alone. However, once it has to do with the Chief Justice herself or himself, the Constitution and its framers said, no, go and consult. I used to live close to a palace when I was growing up in Pandu.
Yeah.
And there was the chief there. People take their conflict to him to solve.
Right.
When he's done, he will say, I'm going to consult Abrewa before the final verdict will come. It's an admission by the chief that, one, all wisdom does not reside with him.
Right.
So he wants to go and consult. So the framers of the Constitution, realizing this, said, no, Mr. President, given the petition, in the case of Chief Justice, well, because this one relates to the Chief Justice, go and consult the Abrewas, here, the Council of State. Now, let's go back to the conversation.
Right.
When President Mahama received these three petitions, what did he do? His spokesperson, the Honorable Felix Kwache, publicly issued a statement and said, the president is in receipt of 3 petitions. In accordance with the constitutional provision, Mr. President would forward same to the Council of State for the consultation process. Just when the president through the spokesperson made this announcement, I think it was a Friday or so, then we saw that a writ had been issued. The plaintiff being my learned friend, Vincent Asifua, MP for, I think, Old Tafo. Perfect. Now, if you look at Relief 1 of the writ, and incidentally, his lawyer happens to be the former Deputy Attorney General, former Attorney General, Godfred Yeboah-Dame. And I will say, if there's anybody that has a better appreciation relative to these impeachment processes, I should think Godfred is. Why do I say so? Because the removal of Charlotte Osei was when he was Deputy Attorney General.
Right.
And he advised Akufo-Addo accordingly on those matters. So he has that experience, having advised a former president on the procedure. So if you look at Relief 1, effectively they say that to the extent that the president through the communication had given an indication that he's going to consult the Council of State as to whether there was a prima facie case, offense the 1992, to the extent that the CJ has not been notified. So I remember me when I saw the Relief 1, I said, in fact, I even posted it on my Facebook page. I said, my brother Vincent Asifua, how did you know that her ladyship, the Chief Justice, was not notified? Are you in communication with her? Is she the one who provided you that information? Not long ago, then another private Ghanaian citizen, for that matter, issued a writ, this time around not with a lawyer. So it's okay. It wasn't long, then the Chief Justice herself, a communication from her to His Excellency the President came public, where she had copied, I think, the Association of Judges and Magistrates, Ghana Bar Association, and some named individuals. What was a prayer or request? That's with sackcloth and ashes. She is beseeching President Mahama to furnish her with a copy of the petitions prior to the Council of State making any determination. President John Mahama, having been properly advised, what did he do? He quickly reached out in a public statement and said, look, Her Ladyship, this communication between your good self and me, the president, ought not to have been copied anybody. And so the president expressed some disappointment. However, whereas she had requested for 7 days, magnanimous as President Mahama is, fair as President Mahama is, and I've always maintained the level of fairness demonstrated by President John Dramani Mahama, we should be applauding him. What did he do? He said, you were asking for 7 days to prepare your response. I will give you generously 10 days to put your thoughts together so that the Council of State will have the benefit. My understanding is that she didn't only put up a response, she actually filed a supplementary response, at least to put up her case. Fair. Not only that, she provided her response with documents to the Council of State. My senior and I here, we appreciate when somebody issues a writ against you, and in your defense you say, I join issues with you. What you are effectively saying is that there is controversy. There is the need for determination by a judge. And that is where, oftentimes, you see that the matters are set down for trial. That is the stage where we are. It's called prima facie. So that on the face of it, it is not frivolous. It is not vexatious. In the sense that it is not like a pack of lies. The person assuming, and I say this with caution, assuming the person says, okay, you have taken 1 cedi. Then you say, yes, it's true, I took the 1 cedi. However, this is the justification why I took the 1 cedi. What it means is that you have joint issues with the person. So now the question is, you need somebody to now make a determination that, okay, the 2 cedis you took is actually in accordance with the procedures that allows you to take 2 cedis and not 3. That is the whole essence of prima facie. Nothing more, nothing else. So at this barest minimum, what exactly has President Mahama done, which is not provided for in the 1992 Constitution? And you see, I want to, on this occasion, salute the GBA President and the Secretary. I've read the statement issued by them for many, many, many years. The GBA President, for the first time, had issued a statement relative to a decision taken by the President, having consulted the Council of State, and they do not fault the President. They only say, ensure that whatever goes on accords with what the Constitution says. And for me, it's a plus. In the past, and I'll tell you this, when President Mahama appointed His Lordship Justice Puaman and Yao Apao to the Supreme Court, the Ghana Bar Association, then led by President Megache, His Lordship, went to the Supreme Court as plaintiff to fault the constitutional procedure President Mahama adopted in that appointment process. Today, the Ghana Bar Association is not saying that President Mahama has done something contrary to what the Constitution says. It only says that, Mr. President, and all stakeholders involved in this impeachment process, we beseech you, hold fidelity to the law. Where discretion is supposed to be exercised, comply with the dictates of Article 296. Hallelujah. I have never seen this high level of applause to a presidential conduct. That is the record of President Mahama. Now, I've always said, and I'll come back to quickly, I've seen a notice of motion, application for interlocutory injunction, again by my learned friend Vincent Asifua, led by his lawyer, Godfred Yeboah-Dame. And effectively, they are saying that the Supreme Court should make an order requiring President Mahama to halt the process and all the stakeholders involved. I just want to read a portion of the Supreme Court decision in Justice Paul Utaderi versus Attorney General. The process should be done in camera, and therefore wanted the petitions and the impeachment process that had commenced to be halted. Listen to the reasoning of the Supreme Court. Next, we believe that the attempt made by the plaintiff herein to abort the process because of the violation of Clause 8 of Article 146, the same provision, by the public disclosure of the petition and its content, brings it in direct conflict with the very constitutional provision which say the process cannot be truncated except in two situations mentioned already. The petition that commences the impeachment proceeding derives its validity from the Constitution. And thus, unless clear intention is expressed, that validity cannot be taken away because they are procedural infringement. This is the Supreme Court. Paul Utaderi versus Attorney General. The duty imposed on the Chief Justice, and in this case, it's the Chief Justice that does the prima facie, because, you know, he said the duty imposed on the Chief Justice to make a prima facie determination is derived from the validity of the Constitution, and that duty, by the terms of the Constitution, prevails until the Chief Justice has performed it. There is nothing in the Constitution that prevents the Chief Justice, here the Council of State, from performing that constitutionally imposed duty once the President has referred the petition to her, now to them. Do you get it? So, clearly, I want to understand, it's a quote, any attempt to stop that process will be subverting the Constitution. So, the very intervention from my learned friend, led by Godfred Yeboah-Dame, is subversive. This is what the Supreme Court said. Any attempt to stop that process will be subverting the Constitution. It goes to confirm that the substantive process commenced by the petition is divorceable from the procedural steps that are or may be put in place to resolve the petition. The procedural steps cannot override the validity of the originating process. Quote, finally, the attempt to abort the proceedings also brings it in conflict with the provisions of Article 1284, 1363, 1394 of the Constitution, which requires that only persons of higher moral character and proven integrity shall be appointed to the various branches of the superior bench. You understand? Thus, when a judge is alleged to have fallen short of the qualities for which he was appointed, he should be investigated. Quote, it is also a matter of public policy that allegations of misconduct, misbehavior against a judicial officer, including a judge, should be properly be investigated. This is the reasoning of the Supreme Court.
Right.
Now you notice that our brothers in the MPP, in all their advocacy relative to this impeachment process, do not allege that an express provision of the Constitution had been violated by President Mahama. In any case, where your relief one is to the effect that President Mahama did not notify the Chief Justice prior to the petition being forwarded to the Council of State, and to that extent it's unconstitutional. In the face of the Chief Justice's own request to the President, and the honoring of that request by President John Dramani Mahama, that relief one had become moot. It had become moot.
Even in constitutional cases?
Yes.
But what about those who argue that, I would wish that we don't spend too much time on this, but how about those who argue that if such a matter can rear its ugly head again, then it's important for the court to deal with this decisively?
As we all know, constitutional matters are fought within a certain factual rubrics.
Okay.
There are facts. You weave the fact against the law.
Right.
Our Supreme Court does not give advisory opinion, and he knows it. Our Supreme Court has shunned away from giving advisory opinion. It is only the exceptional cases where the Supreme Court will say, yes, this event had happened, but because it has the potential of repeating itself, we will still want to delve into it. Most often, once the question of mootness is raised, so if you recall, G.H. Mercer and Attorney General, because President Mahama had won the second term and had repeated his ministers like the Honorable Richard
President Rawlings.
President Rawlings. Sorry. So in this case, where President Rawlings had repeated ministers like Honorable Kwan Pepra and co, the MPP led by the then minority leader, the respected G.H. Mercer, what did he do? He went to Supreme Court. By the time the Supreme Court came to adjudicating, if you recall, President Mahama said, okay, no problem, let them go to Parliament again. And Parliament by resolution handled the matter. The issue of mootness came in. But you see, in this specific case, you are saying that the president ought to have notified a named individual. That is the premise of the suit. No, senior, with respect.
No, absolutely.
Relief one. Relief one. And remember that the relief is what originates or invoke the jurisdiction of the courts. And so where in this case, the specific allegation against President Mahama is that you ought to have notified Her Ladyship, the Chief Justice. It's not a broad constitutional question that calls for an inquiry. You are specific. Then the woman herself, the Ladyship Chief Justice, now writes to the President and says, look, Mr. President, don't forward this. Even if you do, please permit me to respond. President Mahama said, fair. I've given you 10 days. Even though you were asking for 7. What exactly has President Mahama done wrong? Now, I want to demonstrate something to you. Consistent fidelity to the law by President John Dramani Mahama. Somewhere in 2015, a very known MPP activist and a good friend of mine, in fact a brother, Richard Nyama, Progressive Nationalist Forum,
yes,
brought a petition.
I guess with Anodom Prayer?
Yes.
Yes.
Brought a petition that President Mahama should remove his own appointed Shraj commissioner. President Mills had appointed.
Yes.
But, I mean, the NDC at the time he was vice president.
Yes.
So remove her on grounds stated in a petition. Richard Nyama and Anodom Prayer.
That's the NCC boss.
No, Shraj boss.
Oh, Shraj boss, yes.
Emil Short had gone on retirement.
Yes, true.
President Mills with President Mahama as vice.
Yes.
Then appointed Loretta Vivian Lamptey as a replacement.
Yeah.
Now they brought a petition that instead of her going to stay in the bungalow that Emil Short was staying in, she was staying in a hotel. And therefore she had incurred blah blah and raised all kinds of financial issues against her. President Mahama, consistent with his fidelity and the oath he has taken, in 2015, what did he do?
Praise singing. It's
Where is the praise singing?
Look, there's an issue that we are discussing. Let's focus on it and stop this.
Is it not? Is it not? Because look at the oath of office of president. Presidential oath. I, having been elected to the high office of the President of Ghana, do. And then it proceeds. He says, quote, faithful and true to the Republic of Ghana, and that I will at all times preserve, protect, and defend the Constitution, That's the presidential oath. So if he acts in accordance with the oath of office, how is that praise singing? I'm only telling you how he had conducted himself. Back to Loretta Lamte. When this process came in, what did President Mahama? He didn't say because Richard Nyama is MPP activist, he wants to remove an NDC appointed SRAG boss. He didn't say Frank Anodompre, being an MPP person, had brought a petition to remove an NDC appointed SRAG boss. No, he didn't close the Jubilee House to them. He opened it up. They brought the petition. He took receipt of it. Do you know what President Mahama did? He forwarded it to the then Chief Justice, Georgina Wood. Her ladyship, Georgina Wood, did the prima facie determination. Then led by lawyer Samson Ladi Ayenene, as the lawyer for Richard Nyama, President Mahama did everything. Gave it to Chief Justice Georgina Wood. Her ladyship, the Chief Justice, went through the petition, satisfied herself that there was a prima facie case. You know what she did? She set up a 5-member committee, just as President Mahama has done, chaired by His Lordship Justice Eniyebua, Justice Anthony Bennett, Mariama Owusu. Then the two were, 2 Supreme Court and 1 Court of Appeal, and 2 other civilians. They went into the petition. Now guess what? While the petition was pending, President Mahama issued a public statement saying that in order to ensure the integrity of the impeachment process, he is suspending Vivian Lamte. Our friends in the MPP then were quiet. When President Mahama followed the constitutional provision relative to his own appointee, you never uttered a word. Today, President Mahama, in receipt of petition, not known political activists. I understand there is a businessman called Daniel Ofori. The last time I checked, Daniel Ofori is not a card-bearing member of the NDC, unlike Richard Nyama and Frank Anodompre. If Mr. Daniel Ofori brings a petition and the president receives it, say, look, let me go and consult the wise people, the Council of State members. Where is the constitutional infraction? Look, the way our friends in the MPP have proceeded, particularly relative to her ladyship, Justice Torkonoo's, the impeachment process, is quite revealing. Is there any symbiotic relationship between the MPP as a political party and her ladyship, the Chief Justice? Because President Mahama, consistent with his conduct, removed another constitutionally protected individual, Madame Loretta Vivian Lamte. The MPP never issued a praise statement. They never went on demonstration. Another constitutionally protected individual, her ladyship, steps have been taken. Then suddenly, you are all over the place. Does it not betray something? Is it something there that you are not telling us? I am getting worried. Because I have felt that to the extent that President Mahama is following the Constitution, at least we should all hold on to that. Until he makes a mistake. And you see, President Mahama is not in the place of making mistakes. I've always maintained this. President Mahama is so unique. You know why? With the benefit of being MP, 12 years, minister, vice president, president, and president, on this set, I am not sure myself and my learned senior here have the said political experience in handling such matters than President Mahama. It would be a mark of arrogance for me to sit here to even remotely suggest that I am well experienced in handling such complex constitutional matters than President Mahama. And like I've indicated, he went through the impeachment process for Loretta Lamte, removed her, first suspended her, until the Eniyebua committee made their finding, and President Mahama, based on that, removed her. Is it the case? And I'll end on this.
Because I want you to.
Yes.
Yeah.
President Mahama had put a 5-member committee, having consulted the Council of State, which His Lordship Justice Gabriel Puaman chairing it. His Lordship Justice Asiedu, on that, Domlevo Yao, distinguished former Auditor General, whose removal from office by Nana Addo Dankwa Akufo-Addo was described by the Supreme Court as unconstitutional. He's on that panel. At least he has the benefit of how a person can be treated unfairly. And so, such a person will not want to treat somebody if the process does not merit it. Then you have somebody from academia. Then a person from the military. What more fair process can you? Okay, they say, the MPP say, oh, President Mahama appointed His Lordship Justice Gabriel Puaman onto the Supreme Court. Fair. At least the record shows. Who appointed His Lordship Justice Asiedu to the Supreme Court? Nana Addo Dankwa Akufo-Addo. He took him to the Court of Appeal and took him to the Supreme Court. You don't trust Justice Asiedu any longer. The last parliament, the panel that faulted Speaker Bagbe, you remember, the last end, the Afenyomakin suit and all those. The lead author of that judgment was Justice Asiedu. Suddenly, our friends in the MPP no longer trust the judgment, the reasoning of His Lordship Justice Asiedu. Is that the point?
Okay.
Look,
So these are I'll call these are preliminary.
I mean, so let's just be fair. There is a video I wish you would play for me.
In
the process of the removal of Charlotte Osei, my learned senior arguably describes himself as the mighty minority leader, my senior Afenyomakin. Maybe if we can
this
listen,
is the video you're talking about.
the video. If we can listen to him.
Okay, so right after this video, the Honorable Egyapa Mercer, I hope I got the pronunciation this time correctly. Mercer,
yes.
Mercer, yes. Would come in. So let's watch this video.
Uncle Kwekubako was very candid. See, the president knows the politics of this country. So he was very specific, made reference to the petition, unsigned petition, the subsequent communication he received from the council, and all that. So he left it as it was, which is fundamentally different from what my respected colleague was trying to put out.
In other words, the president made the Chief Justice aware of the deficiencies that may be in the original.
He left it as it.
He didn't just send it. He wrote
Of course,
pay attention that these are the issues. And I'll leave it to your judgment.
Exactly. You see, we are talking about developing institutions. And if each time institutions try to assert themselves, we turn around to bastardize them, then I'm afraid we're not going to get anywhere. Is it the president who has removed Charlotte Osei? Or it's an institution that has done its work in accord with law and has thus made a recommendation for her exit? The NDC may not be happy because they appointed the woman to head NCC. They tried to push her to the Supreme Court. The Judicial Council did not agree. She was rejected, and eventually she was sent to the Electoral Commission. The MPP as a party opposed the procedure for the appointment of the EC chair, and I led the charge. Eventually in court, my client was Richard Sky. It was not Charlotte Osei. They shouldn't get it wrong. The MPP opposed the procedure. However, we looked after if the eventual appointment and the decision by the Supreme Court endorsing the procedure and all that. You remember I even raised the issue of contempt, that while the matter was yet to be tried, Mr. President had gone ahead to appoint and order, and I felt that it was inappropriate. But look, it didn't get anywhere. So when Charlotte was appointed, as a party, we had issues with the background, and we did not hide from that. But it was not an NDC MPP person. It was not Kennedy Japan. It was not Gabios Asardako who petitioned the president for the removal.
We're still live on Good Morning Ghana on Metro Television. We'll be right back.
Every way in summer, Honorable Edudzi Tamakloe, National Petroleum Authority, Honorable Egyapa Mercer, MP for 2nd constituency in the Western region. Utie nkomona Sir Chief Justice in same way no something which is there. I just say emrane nko any bit me edi huduma because we have prima facie cases or whatever the judges or the lawyers no obo calling for. This is not the first time a deal will happen. We had the same procedure. Brian Mami Charlotte Osei na ohono. Inchayana nkofo binum ka say this is a political witch hunting or politically motivated. Ayana mimega mitiano although say minyanko law school, but kakra yesua edi ye twitwa ye ho kakra ye nso ye ti asefa any the wisdom ayankopon di amaye nyansa kakra ye wo ayen so ye di ejeji bibin ekrese. This is not about witch hunting. Nkofo ka say NDC for wa ban mo mukai sorry mo opposition mo kai say the judicial system no enkoye ampa Yura John Mahama one said say omoba they will make sure they will reset the judiciary, but again Ghana for money John Mahama ya adwen resetting Ghana and na monene MPP for bi nene nya adwen on resetting judiciary. I am asking, our judicial system is one of the key components, is one of the key arm of government. One of the key arms of government. We baby, me say we executives free honoma. Even that 3 arms of government, it is say when uhene wano we ear. We have 5 sensitive parts of human body. Yes, when uhene wano waso. Yes, 1, 2, 3, 4, and other one become. Sad we. Any of them edamejia, you are in trouble. So wasusia, you are in trouble. Sabi ebudu sabi nyando yemuma, you are in trouble. Weniba, you are in trouble. Ohene entiadia, you are in trouble. Any of them no, you don't wish say ebeba yenso. Obi be prefer say ni nan sabi ebudu sabi nyando, ni nan bitwa danse na so bisi. Obi be prefer say sabi ni sabi twa chense ni nibebo. And it is true. You can say choose between say sabi twa anywhere nibebo. Everybody will choose say me sabi twa danse mani bebo. Real example keke because enino ene the light of the day. Enino ene the light of the body. Enti one person weni ebebo da. Na nipa nguye weni die eboye de. Yameka ina kwesi ni say judiciary no one of the important arm of government. Any concept any any corruption be akoso because eduru baby na Ghana for ye wugidie bi say uko judicial system mu a case no you can predict say say nebeko ampa ombewie case no now it is on that direction. It tells you how loose and how the incompetent the judges were during those time. Inti amankofo nya gidie bi say judiciary no it is gradually losing its credibility. I was say the next government should reset it and should be investigating it. Eti no na ema Yura President John Dramani Mahama ko gine baby o ka say judiciary ni nkoye and even se mo beka ya sa the HS Ghana ye uye Ghana ni oma wo Ghana no but then Torkonoo si ukita birth certificate and chess oma wo Ghana ukita Ghana card muma chess oma wo Ghana na Ghana card me the na guarantee for me kai bra me ko Ghana card we use birth certificate and they use two guarantors. It is a way to make us say birth certificate in India na we want the Ghana card. Say the basic component that brought up Ghana card was what? Certificate, birth certificate. Eti mami we enema bi a oye mbra bi o hye ene ma NDC for dia hometie ka se ba e be hwehwem apa eno mo ba mo hwehwem and me Torkonoo kwa e be me de because Torkonoo was acting as if so ye MPP National Women Organizer kin jemfu akra na onye sa ye kan we na MPP for mpeso mbeti no ba e be cancel because ade bi oye bia no it was in favor of MPP bia no mo aban wo e ma di kan ka kire mo ma bia ntagi mega metie se bi NDC de men hwe men kan kire me se bi NDC de because na ye beto aba no ye campaign party ma Canada Japan and you know it wa wo hwe me ma me no mo UK me papa no mo UK me ma me no mo US me ma me no mo Canada mo hwe me free all parts of the world na no they know clearly say me ye massive campaign ma Canada Japan but MPP for suban ya ka say bi nkofo ntiase no echinchim Canadians edima Bawumia nti say basa na mimi nko support Bawumia. No, I will never support Bawumia. I will support NDC. So for that matter, I did another campaign for NDC and NDC for Babaim. But NDC aba na so wonso ye nima bi ensem fata. The same thing I'm here campaign more is the same way I am going to criticize them and I'm going to bash them, blast them for them to do the right thing. Etianemetiano na jo Mahama ye nima papa na meka. Don't think say bega kwa so NDCD bega NDCD bega NDCD me fa political party nye hwe okrum ha e Ghana na ye chichire any political party oba bi dis for ye Ghana ye we will support the person or the political party and the government but oba na obedi semfo we will what blast you. That is our core mandate on this platform. Enti ohwe me na wo ka chem se me NDC ni a I am not NDC, neither MPP. I do not belong to any political party in this country. But I give my support to that government and I will make sure that government will get my full campaign during another election. It is NDC for the papa. That's a muku in 2028. Muku Chief of Staff say Omedi Party and Julius Debra. Hey, you better rubbish. I'm telling you. You better campaign Tiano. Rough or can you embashino? And that is how a tear. And Madame Torkonoo dear, she must go. Torkonoo must go. Onye Ghana must go, but Torkonoo must go. And you know, say at the end of the committee report, Torkonoo will surely go. The mess also document betum. Now I like it. Now I share now for any beer. Hanum still remains #1 platform on Mega TV, on YouTube. I go so seven the best of news. Me mama cheba for United States of America, New York, mama yankopon shira, mama roya bi UK, and obi bia hwe Mega TV no. Yankopon ko so a shira. Makra wo, fidi ameje so a ene Mega. Bye bye.